Your kind of music, all day, all night, right here on your only station, Pawa Radio.
Well, good evening to you. This is Sheria Dive with me, James WaNjeri, right here on Pawa Radio. And of course, it's Monday. And what a better way to start the week than to start by talking Sharia. Tomorrow, 14 years ago, is a day that Mwai Kibaki held up the Constitution of Kenya. I believe it was at Uhuru Park or was it in Nyayo Stadium? I have to check that and confirm that. But the Constitution was promulgated 14 years ago today. And there's been that argument. Is it still a new constitution? But I think the more we live under this regime, we realize, hiyo katiba bado si mzee hivyo, because things are still happening to it. So today we're going to discuss some of the challenges that the new constitution faced. And of course, we have to begin by remembering that at the time, we had majority of the government where the president and the prime minister, President Mwai Kibaki and Prime Minister Raila Odinga, were on the yes side. But on the no side, we had cabinet ministers, William Ruto, who was the Minister for Higher Education at the time, Naomi Shaban, who was the Minister for Special Programs, and Samuel Pogisho, who was the Minister for Information and Communications, who were in the no camp. William Ruto was actually the head of the no camp, seeking to get a no vote against the Constitution. And of course, majority of the church leadership was also in this no camp, seeking to vote against the new Constitution. And they had a red card, all right? Because that time there was red for no. But before that, in the year 2005, there had been another referendum that had been carried out. This time, of course, you'll remember that Raila Odinga, who was at the time the Minister for Public Works and Transport, actually it was Public Works, he had led a section of the government in opposing the Constitution as a result of what they termed to be President Mwai Kibaki's betrayal of the memorandum of understanding they had. Manze, Kenya is once let's go to the biggest history country. Kenya is a circus. This country is worse than a Mexican telenovela. So in 2002, Uhuru Kenyatta and Mwai Kibaki face off in the elections, and of course, Uhuru Kenyatta had been fronted by former President Daniel Arap Moi to be the flag bearer for KANU. KANU had been in power since 1963 until the year 2002. All right? You can do the math and tell me what that comes to. And a lot of the people who were supporting Mwai Kibaki, some of them had been in KANU, including people like George Saitoti. Of course, you'll also remember that before that, our friend, Prime Minister Honorable Raila Odinga, had actually taken his party to the Jogo. The party was called National Democratic Party, NDP. Okay? Asema tinga ilimezwa na Jogo. And then, a few months later, Moi says Uhuru Tosha. And Raila bolted out of government, and they went to support Mwai Kibaki. And you remember, Mwai Kibaki was also part of the KANU government in the early days, in the 80s, the 70s, 60s, 70s, 80s. And then he left to join the opposition. And he first vied in 1992, then vied in 1997. 2002 was his third time to vie for the presidency. So Raila went to Kibaki and said, Kibaki Tosha. And so we had a new government in 2002. This was called the Rainbow Coalition, NAC, National Rainbow Coalition. Then, of course, as things happen in Kenya, watu wakakosana. But there had already been a push to bring in a new constitution, and there was a team led by Professor Yash Palgai. Big up, Professor Yash. And at that time, in 2005, there was a referendum, and that was the orange versus banana referendum. Banana was yes, and the orange was no. That is where ODM came from. Orange Democratic Movement, that is where it came from. But before hata uende sana, there used to be ODM Kenya. The original party was called ODM-K. But then, Kalonzo and Raila also akakosana. So Raila had to go and get ODM, Orange Democratic Movement. And of course, the no vote won against the yes vote. And so Kenyans in 2007-2008, we get into post-election violence. There's a civil strife. People are killing each other all over. Then we come together in a handshake. And the handshake agrees that one of the things that you're going to do is to ensure that we have a new constitution for this country called Kenya. So in the year 2010, we then head to the elections for the new constitution. And on 4th of August, that was my first time voting. I remember I woke up very early to go and vote yes for the constitution. On the yes side, we had President Mwai Kibaki, we had Raila Odinga, and a majority of government, and a lot of the civil society as well. And on the no side, we had William Ruto leading that no side, and he was joined by clergy, including Pastor Wilfred Lai of the Jesus Celebration Center, Bishop Boniface Odoyo of Nairobi Pentecostal Church, which is now known as CITAM. And we also had some detainees, guys who had been detained by Moi, Njeru Kadhangu and WaNjeri Kihoro. They said Chapter 9 of the new constitution created a super imperial presidency with absolute and draconian powers. Now, the voting happened on 4th, and the results came in, and 67% of Kenyans had actually voted for the new constitution, which we have today. Today, we're going to be talking about some of the intrigues, because someone did go to court at around that time. Someone did go to court, and when they went to court, they said, we need to stop the promulgation of this constitution. So today is more of a history lesson as we gear up for tomorrow, which is the anniversary of the promulgation of Kenya's constitution. And on Saturday, remember, I'll be having a panel here of some brilliant young people who'll be telling us about what they've done to protect and to promote the constitution of Kenya. So for now, let's get some music, and then when we come back, we talk about that case. A lady by the name Mary Ariviza. Why should you know the name Mary Ariviza? And what did she want the court to do for her? This is Sheria Dive right here on Power Radio.
Your kind of music, all day, all night, right here on your only station, Power Radio.
Now, I'm looking at an article here in the Daily Nation newspaper. This is an article of June 9th, 2010. Do you ever wonder what were the talking points for the No team led by William Ruto, who was a minister at the time? According to Ruto said that the election or rather the referendum was a contest between those who want to put meaning to change and those who want to change because it is fashionable. God willing, we are going to win. God has always showed up in this guy's speeches. He says, with regards to the provisions, William Ruto had this to say. He said, we want to encourage committee of experts, which has now been baptized committee of errors, to assist our brothers and sisters in yes with some civic education. He further said that rather than vote on account of excuses, you're going to vote on account of reasons. It takes reason to stand on no side, which is pushing this country not to adopt a faulty constitution. We must not allow desperation and excuses to allow passage of a constitution that legalizes shedding of innocent blood. All right? Now, what are some of the talking points for this no campaign? One of the key issues, it appears, was land. All right? Now, according to this article, the speakers at the launch, among them were Assistant Minister Wilfred Machage and Mount Elgon MP Fred Kapondi, warned of eviction of some communities from Rift Valley, Nairobi and Nyanza if the new constitution is passed. This was in 2010, so walikuwa nauza uoga vibaya sana hapo. Mutahamishwa huko. That's what they said. Mr. Kapondi said, we will not accept to suffer while people sit on our land. All right? And he named Bungoma and Trans Nzoia as belonging to his Sabaot community. So basically he was saying, Bungoma and Trans Nzoia ni yetu. We will not accept to suffer while people sit on our land. That's the same guy who's saying that people will be evicted if the new constitution is passed. Then there was also a talking point that the proposed constitution would further breed animosity between Christians and Muslims due to the inclusion of Catholic courts. 14 years later, I have not seen anything like that. Now, Mr. Machage, who is deceased now, may he rest in peace, said that President Kibaki could be taken to the ICC at The Hague by November if the proposed constitution is passed, as it strips him of immunity. Surprisingly, the widow of a former Chief Justice Cecil Miller Christine also said that the yes team had not gone out to parts of Central as they know they will be stoned and told it is a no zone. Dr. Naomi Shaban, who was the chief guest at that event on the 9th of June, said that many constituencies in northeastern, eastern, coast and Rift Valley would be scrapped if the new law is passed. Listen to that. Many constituencies in northeastern, eastern, coast and Rift Valley will be scrapped if the new law is passed. This was an outright lie. No constitution was scrapped. As a matter of fact, the number of constituencies was increased. Now, the No team also cited provisions on sovereignty, Bill of Rights, economic and social rights, equality and freedom from discrimination, and the executive as some of those they were against. They were also against the provisions on land, representation, equity, devolution, the youth, and amendment by popular vote. All right? The group was also unhappy that any treaty or convention signed by Kenya shall form part of Kenya law under the proposed constitution and that there is room for abortion if permitted by health professional. We spoke about abortion on this show, I think, about a month ago, so you can find that on YouTube. Very interesting conversation about what the court was, the guideline the court was giving on what exactly is abortion. The No team was also opposed to every person having a right to the highest attainable standard of health, including reproductive health care, terming it abortion on demand. What the No team was saying is that you can just go to a hospital and say, I want to abort this baby, and number, Shika abortion. You get an abortion, you all get an abortion. That is what the No team was saying. Now, of course, one of the key things Mr. Ruto said that homosexuality is allowed in the proposed constitution through a provision. The state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, ethnic, or social origin. On the question of land, the No team said that the National Land Commission had been given extreme powers, adding that legitimate landowners have also been denied protection. Igembe South MP Mithika Linturi, who later became a cabinet secretary in President Ruto's government, said that the 47 counties contained in the proposed constitution ignored population density and size. The group added that it will be difficult and expensive to amend the new constitution. Mr. Linturi is on record saying it is easy to go to heaven and change the proposed constitution. Samuel Pogisho accused the Yes team of forcing Kenyans to vote in favor of the proposed constitution. Dr. Naomi Shaban said the proposed constitution would further outlaw the CDF. On that, she was right. She said that some of the leaders in the Yes camp were supporting the No campaigns but did not want to come out openly. Now, you'll be surprised. Some of the people who are present at this meeting, former Cabinet Secretary Lina Jebi Kilimo, MPs Luka Kigen, Daniel Moki, Peter Kilo, Benjamin Langat, Zakayo Cheriot, Moses Lesonet, Julius Kones, Peris Simam, Isaac Ruto, Cyrus Jirongo, Kiama Kilonzo, Sami Moita, and Joshua Kutunyi. And of course, there were some apologies that were sent by one Peter Munya and Silas Muriuki. Those were the talking points for the No campaign. And I remember abortion was very big on their list. Abortion, homosexuality. There was also the idea that because of Catholic courts, we are going to be a country that is ruled by Sharia law. You know, the talking points at the time were Muslims are going to come and take over. Guys, we need to be scared. They were selling a lot of fear. But on the 4th of August, Kenyans said, we heard you, but no. 67% of Kenyans voted for the new constitution. But before it could be promulgated, a lady by the name Mary Ariviza went to court and filed a case in court. What did she want? She wanted to strike, she wanted the court to stop the promulgation of the new law. All right? So we're going to be looking at that case today because remember, just merely because the people had voted, that was still not sufficient. There are still plans to try and stop the new constitution from being promulgated. So today, we're looking at that case. That is Mary Ariviza versus Interim Independent Electoral Commission of Kenya and another. This was a 2010 case. And a decision was given on August 24th, which was 3 days before the promulgation of the constitution by Justice Hannah Okwengu of the High Court of Nairobi, as she was then known at the time. I believe now she's at the Court of Appeal. So when we come back, we begin to look at this case as we see what exactly did Mary Arivisa want with regards to the new constitution, and why did the court agree or disagree with her? This is Sheria Dive.
Your kind of music, all day, all night, right here on your only station, Power Radio.
It's house, right here on Power Radio with me, James WaNjeri, on Sheria Dive, and we're looking at the case of Mary Arivisa. Mary Arivisa alikuwa anataka what was that thing we used to say? Alikuwa anataka kuzima stima kwa bash. She filed a suit in August of 2010, seeking to stop the promulgation of the new constitution. Now, according to her, she argued that there are some processes that had not been properly followed. She had three arguments. Number one, there was a format in which the results of the referendum were to be published. Okay? There was a format in which they were to be published. But she argued that that format, under Regulation 36(1) of the Constitution of Kenya Review Referendum Regulations, it was outside of the law. It was extra law, okay? It was going against Section 43(1) of the Constitution of Kenya Review Act 2008. The second thing she said is that the Gazette notice, which purported to be a certificate of the results of the referendum, did not conform to the format that had been set out in Schedule 2 of the Constitution of Kenya Referendum Regulations 2010. And finally, there had been some contradictory reports regarding the publication of a valid notice of the final results of the referendum. Now, the Attorney General had been brought into this case as a second, as a party. And according to the Attorney General and the then Independent Electoral Commission, IIEC, they raised a preliminary objection. And basically in law, a preliminary objection is when you object to a suit that has been filed, but on a point of law. You're saying that the law here, there's a legal issue here to be determined. If it's determined in your favor, then the court will be thrown out, okay? So they raised a preliminary objection to the hearing on the application on the issue of jurisdiction. And the argument for them was this. Section 60A1 of the Constitution provided the following. Notwithstanding Section 60, there shall be an interim independent constitutional dispute resolution court which shall have exclusive original jurisdiction to hear and determine all and only matters arising from the constitutional review process. Okay? So what was the argument here? They were saying, insofar as we're trying to deal with a matter that is arising from the constitutional review process, which led to the constitution, draft constitution, which led to the voting and all that, Section 60A1 of the Constitution explicitly placed the question of dealing with such a dispute outside of the High Court. There was an interim independent constitutional dispute resolution court which had been created and which had exclusive jurisdiction to deal with the matter, since it was a dispute arising out of the constitutional review process. Now, what is jurisdiction? Hii word utaisikia sana. Jurisdiction basically is what causes a court to sit and listen to a matter. Okay? So when you say a court has jurisdiction, we are saying it has the legal right. And if a court has no jurisdiction, then it means it has no right to deal with that. Now, Kenya's court system, we have the High Court, and then we have specialized courts. You have the Environment and Land Court, and then you have the Employment and Labor Relations Court. So this means that you cannot bring an employment matter and take it, let's say, to the Environment and Land Court. You'll be told we have no jurisdiction. Us guys, we only deal with a specific thing. So think of jurisdiction as ring fencing. That sometimes you'll have the specialized courts like the Environment Court. The Environment Court deals with matters of land, where the dispute is about land, okay? The Employment Court deals with disputes where it's on employment. The High Court has unlimited original jurisdiction, which means they can handle anything. They can listen to any case. However, if you go to the High Court with a matter that is supposed to be for the Employment Court or for the Environment Court, watakwambia, boss, you need to go to the specialized courts, although they also have the same, they're also at the same level as the High Court. Now, what our sister Mary Arivisa was trying to do was to get a judicial review. And judicial review basically is the power that the court has to review the decisions of an administrative body. Okay? So let's say, for example, tomorrow, the county government of Nairobi says, we are now going to charge everyone 100 shillings to breathe oxygen in the CBD. Okay? That is a decision that has been made by an administrative body. You then go for judicial review. And in judicial review, you are either asking the court to stop that decision, okay? You are either asking the court to tell that administrative body to do a certain thing, okay? Those are the things that you're seeking in when you're talking about judicial review. And because this is not law school, I'm not going to bore you with all the many details. But there are certain orders that you ask for when you go for judicial review. Now, according to the Attorney General and the Electoral Commission at the time, they were saying that the law and the Constitution were expressed on the authority and jurisdiction of the High Court. Okay? This was not a normal executive act which could be the subject of judicial review. However, Mary Arivisa, on the other hand, said that if you look at that section 60 of the Constitution, it says the High Court is a superior court of record as opposed to the interim independent constitutional dispute resolution court. So her argument was that the only jurisdiction of the High Court, which was limited by section 60 of the Constitution, was a civil and criminal jurisdiction to the extent that it touched on the constitutional review process. She was of the view that the special jurisdiction of the High Court to determine matters of judicial review conferred under the Law Reform Act was not limited. So she was basically saying, I should be able to come to the High Court because the High Court has unlimited original jurisdiction. They should be able to handle everything. But on the other hand, you have the Attorney General and the Electoral Commission saying, no, the Constitution at Section 60A clearly states that when you're dealing with a dispute that comes out of the constitutional making process, then there is a special court that has been set up, which is the Interim Independent Constitutional Dispute Resolution Court to deal with that matter. Okay? Now, she also said the Attorney General and the Electoral Commission are also of the view that if you look at the Constitution of Kenya Review Act, the only relief which could be granted by that special Independent Constitutional Dispute Resolution Court, they would only grant reliefs based on a petition challenging the conduct or result of the referendum. They could not quash the Gazette notice. They could not revoke the Gazette notice or to try and stop the promulgation of the Constitution. So the court here, when looking at all these issues, determined that the issue here is whether the complaint could be determined by way of judicial review and whether the High Court had jurisdiction to hear and determine such a complaint. Okay? The court began by reiterating that Section 60A(1) of the Constitution expressly suspended the jurisdiction of the High Court to deal with matters relating to the constitutional review process. So what had happened here is, while we were getting into the process of bringing a new constitution, people asked themselves the question, if someone has a dispute or if someone wants to dispute how we have voted or how this process has gone, what is a proper way to deal with that? Where should they go? Should they go to the High Court? They said, no, we're going to create a special court. And that special court is the one that is going to deal with that matter. So the first thing is that the court observed that it was evident that there was a deliberate action on the part of Parliament through Section 60A of the Constitution to create a special court other than the High Court. And that court had a specific mandate, that was hearing disputes concerning constitutional review process for a given period. In the eyes of the court, in order to achieve that purpose, Parliament deliberately temporarily suspended the powers of the High Court with regards to the constitutional review process and gave the powers to the interim independent constitutional dispute resolution court. The court held that, contrary to the submissions that Mary Arivisa had made, the powers of the High Court, which was suspended during the lifetime of the interim independent constitutional dispute resolution court, were not just original jurisdiction of the High Court. Because her argument was that here we're dealing, it would only matter if you're talking about criminal and civil matters. No. We're told no. This includes all other powers specified in Section 60 as relates the constitutional review process. Okay? When we come back, we'll look at what the court also considered as where does her cause of action fall? This complaint that she has, where does it fall and how should it be dealt with, especially as we talk about the Gazette notice. Remember, we're talking about the case by Mary Arivisa versus the Independent Electoral Commission, and she sought to stop the promulgation of the Constitution, which took place tomorrow, 14 years ago, on the 27th of August 2010, after Kenyans had voted on 4th of August 2010 for the Constitution. Overwhelmingly, 67% of the population said yes. And remember, part of the background there was that the yes team was led by the President, Mwai Kibaki, and the Prime Minister, Mr. Raila Odinga, and the no team was led by Mr. William Ruto. So when we come back, we look at the question of the Gazette notice. How was the court going to determine the question of that Gazette notice? This is Sheria Dive, right here on Power Radio.
Your kind of music, all day, all night, right here on your only station, Power Radio.
Man, what happened to Kamula, man? If there's a loss we've had as a country, it's Kamula. And I don't know why no one went to the High Court to stop that breakup. Now we'd just be having bangers after bangers. That's Hold It Down by Kamula. Just taking me back to all the way to Kampo days. My age is showing. Anyway, we're back to the case of Mary Arivisa. And in this case of Mary Arivisa, the High Court was of the view that, hey, Mary, look, this decision, remember, was being made on the 24th of August, just 3 days before the promulgation could be done and before President Kibaki could hold up that constitution at the, I believe it must have been the Uhuru Park. So the High Court said, when Parliament was looking at the constitutional making process, they agreed that when it comes to any question or anyone that would have any questions about the process that has been carried out in going ahead to have the referendum, in voting, in all that, they created a special court which they call the Interim Independent Constitutional Dispute Resolution Court. Okay? That court is the one that has the power and has the authority to deal with your dispute. Unfortunately for you, Ms. Arivisa, you've brought your dispute to the wrong place. And as a High Court, we will not be handling your matter. And so her case was dismissed. And 3 days later, Kenya was having a new constitution. What's your favorite clause in the constitution? What's your favorite article in the constitution? You think about that, because on Saturday, as I said, we're back here. We'll be having some heavyweights here on the show, just telling us about some of their journeys since 2010 as they've dealt with legal practice. It will be a very interesting conversation. Make sure you join us here on Saturday between 1 and 3 p.m. We'll be talking about the Constitution so far, the gains, the losses, the threats, and what opportunities as well lie for us as Kenyans with regards to this Constitution. Of course, we're also peeling our eyes on what's happening in Kenya. As you know, today the president said that NIS guys will be taught how to handle guns, just in case they are needed to respond to a security situation. And when I saw that, I just thought to myself, hey, is the president now saying he wants NIS to come and deal with protesters? Because I think nothing really shook him. So I said, okay, let me not preempt what's trying to be done here. But yesterday there was the town hall on the new fee structure, new funding model for universities. And I saw a few of the university students really give the president a piece of their mind. And that's good. That's how democracy should work, that the leadership should be able to come and listen to what the people are saying. Because remember, what Kenya's constitution envisages is that the people get the leadership that they deserve, that the people get to be governed in a way that respects them and in a way that honors their dignity. So we're looking forward to tomorrow. Make sure wherever you are, you just raise one up for the Constitution of Kenya. Tomorrow is a beautiful day and it's a day we should never ever forget. But you know what the president is doing tomorrow morning instead of talking about the Constitution? He'll be launching Raila Odinga's Africa Union campaign. That's Kenya for you. Why don't you have a lovely evening and a lovely rest of the week? Remember, this country, it's our country. And one day, we're going to win. God bless you.
Your kind of music, all day, all night, right here on your only station, Power Radio.